Judgment in the matter of Gilham versus Ministry of Justice.
The issue in this case is whether a district judge qualifies for the protection given to whistleblowers in the Employment Rights Act 1996. This depends upon whether she counts as a worker or a person in Crown employment, as defined by that Act. Judge Gilham was appointed a district judge in 2006. After 2010, there were major cost-cutting reforms affecting the courts in her area and the cases in which she sat. She raised a number of concerns, in particular about the lack of appropriate and secure courtroom facilities, her severely increased workload, and administrative failures. She raised these initially with local leadership judges and senior court managers, and eventually in a formal grievance. She claims that she was subjected to various detriments as a result, which led to a severe degradation in her health, psychiatric injury, and disability. In 2015, she raised 2 claims in the Employment Tribunal. Both depended upon her being a worker within the meaning of the 1996 Act. One claim was for disability discrimination under the Equality Act 2010. That claim is proceeding, although currently paused pending the outcome of this appeal, because it is derived from European Union law. And this court held some years ago that, for the purpose of claims derived from European Union law, the 1996 Act has to be construed so as to include a judge within the definition of a worker. However, the protection given to whistleblowers under the Act is not derived from European Union law. The Employment Tribunal, the Employment Appeal Tribunal, and the Court of Appeal all held that a judge is not a worker for this purpose. She now appeals to this court. There are 2 types of worker under the 1996 Act. One is employed under a contract of service. All are agreed that judges are not so employed. The other is employed under a contract whereby she, quote, undertakes to do or perform personally any work or services for another party to the contract whose status is not, by virtue of that contract, that of a client or customer of any profession or business she is undertaking, end quote. No one doubts that a judge undertakes personally to perform work or services, and that the recipient of that work or services is not her client or customer. The problem is whether a judge is employed under a contract. Judges hold a statutory office. Office holders may or may not hold office under a contract, depending upon the manner of engagement, the source and character of the rules governing their service, and the overall context. In this case, the essential components of the relationship are derived from statute and are not a matter of negotiation. It is difficult to identify an employer. The separation of powers between the judiciary and the executive points against there being a contract between a member of the judiciary and a minister of the Crown. Accordingly, there is not a contract to perform services here. Nor are judges in Crown employment. They are not civil servants or the equivalent of civil servants. However, subjecting a whistleblower to detriments such as bullying and victimization would be an interference with her right to freedom of expression, protected by Article 10 of the European Convention on Human Rights. An action under the Human Rights Act would not give her the same remedies as would a claim under the whistleblowing provisions of the 1996 Act. Thus, denying her those remedies would be discrimination against her in the enjoyment of her convention rights, contrary to Article 14 of the Convention. Article 14 requires that the enjoyment of the convention rights shall be secured without discrimination on any grounds such as race, sex, and a number of other listed characteristics or, quote, other status, end quote. First, the facts of her case fall within the ambit of Article 10. Second, she has been treated less favourably than other people who make the responsible public interest disclosures protected by the 1996 Act. Third, being a judicial office holder is clearly a status for the purpose of Article 14. And fourth, the difference in treatment is not justified as a proportionate means of achieving a legitimate aim. There is no evidence that either the government or Parliament addressed their minds to this difference in treatment, nor has any legitimate aim for it been put forward. Under Section 3 of the Human Rights Act, the Court has a duty, wherever possible, to read and give effect to legislation in a manner which is compatible with the Convention rights. It was possible to read and give effect to the definition of worker in the 1996 Act so as to include judges when this was required by European Union law, so it must also be possible to read it in the same way when this is required by the Human Rights Act. Nor does such a reading go against the grain of the 1996 Act or offend against any constitutional principle. Accordingly, the appeal is allowed and the case remitted to the Employment Tribunal on the basis that the appellant is entitled to claim the protection given to whistleblowers by the 1996 Act. The Court will now adjourn.